Good evening, Chairman Keeble and members of the committee. Thank you for the opportunity to come here and speak. My name is Kelly McElroy, and I'm here representing Attorney General Peter Kilmartin. And I'm here speaking or addressing four bills. The first is House Bill 5730, which I'd like to thank Representative Slater for sponsoring on behalf of the Attorney General, as well as House Bill 5729, 6040, and 6039. The first one, which I think is the simplest, is 5730, which relates to the national background checks for individuals who are applying for concealed carry weapon permits. Basically, that act is seeking just to amend sections of 1147.11 and 1147.18 to provide that applicants have to undergo a background check with that requires fingerprints that are processed by the FBI, and also that the applicant would be responsible for those costs. Currently, our statutes basically don't permit that to happen. We basically go through an exhaustive checking the state criminal histories using what's called the III, which is the Interstate Identification Index, and the National Crime Information Center, NCIC. Basically, we use people's names and dates of birth. We have a system at our office that would allow us to use fingerprints, which would make it a much more efficient and accurate way of doing background checks, but the FBI requires that there be enabling language in the state statutes before they permit us to use their database to do that national background check. So basically, we're just asking the legislature here to put that language in so that we can put into effect. I think it's as simple as putting a code into the machinery that we have and being able to perform those checks. With respect to 5729 and 6040, which really both speak to reciprocity, the Attorney General is opposing those bills. The decision to grant a carrying concealed weapon permit is a very serious authority that has been granted to the AG by the legislature, and he takes that, and my office takes that very seriously. The granting, the denial, and on occasion the revocation. And the reason we take it so seriously is because it so seriously impacts public health and safety. And the reason we have concerns about the reciprocity bills is that we believe that the reciprocity agreements threaten that very public safety. As you can imagine, jurisdictions all around our country have varying degrees or requirements with respect to their minimum standards when they define the person who should be walking amongst our citizens with a hidden and loaded pistol or revolver. And I appreciate the efforts that were made by the proponents of this bill to say that, you know, we're not going to recognize reciprocity with counties or states or municipalities that have laws that are less stringent than ours. But that's impossible to do. You can't just say, oh, we'll look at, you know, this particular state's process and say it's just as good as ours. First of all, you have to look at their application process. Some of them don't ask for the information that we ask, and that's another concern we have, is that the legislature is trying to change our application and the information that we can ask for. I'll get to that in a moment. But another larger concern is the fact that when we review the applications at our office, we're looking at the applicant and the application through the lens of someone who is familiar with and knows what's best for the people of the state of Rhode Island. This bill is asking us to accept what some issuing authority might have done in some remote county in Montana and took into consideration that perhaps the nearest, you know, law enforcement barracks was, you know, an hour away or something like that. Just completely different criteria, and there's no way for us to say, all right, well, they did just as thorough of a job vetting out this applicant in that obscure county as we would do here. We know what's best for our citizens, and we've been doing that job for years. I can give you some figures as far as how many permits we have issued that are currently active in Rhode Island, but we're the agency who's been doing it on a greater scale than any of the cities and towns, and I think even Whip Edwards commented that we're doing a pretty good job. Our standard is correct, and I'm not aware of any serious concerns as far as how we're handling it. I heard Mr. Sakosha talk about how we can have this immediate verification system in place where we can determine that a person who presents a carrying permit from another state or city or county, and we can immediately verify it. That's not going to happen. We can't even immediately do it for Cranston. We can't do it for ones that are issued from Warwick PD. We don't have that system in place. And when you talk about the number of issuing authorities there are out there, we can't do it for the 39 cities and towns in our own state. And I just quickly, while I was sitting over there, looked up California has 58 counties. Texas has 254. There's no way that we can ask our law enforcement officers to look at an ID and say, oh, I'm familiar with this one, I know it's legitimate, and accept it. The other thing is, again, I appreciate the efforts that were made to, in this bill, well, let me back up for a second. Our statute requires that a CCW permit holder be 21 years of age. Many states in our country only require 18 years of age. The bills that have been presented have said, well, we won't recognize it if someone is younger than 21. So there was that effort to at least keep it similar and as protective as ours is. But our requirements for renewal applications, actually for new applications and renewals, is we require individuals to qualify. Show us that you're proficient and safe in the use of your weapon that you're carrying around. Many states don't have that, even our neighbor Massachusetts. The first time you apply, you have to qualify, but you never have to do it again. You can be, every time you renew these permits, you don't have to qualify. We require that qualification every 4 years. So now we're going to say that someone who has had a permit for 30 years in this other state or county is coming here, and we're fine with them carrying around a hidden loaded weapon, and they haven't had their eyesight checked. They haven't, done anything to illustrate to us that they are a safe carrying permit holder. So I would say you can't say that we can just rely on these other states and say they've done just as good a job as we would have done. Another thing is I guess I'm kind of going to talk about this in conjunction with House Bill 6039. First of all, our application right now asks for individuals' arrest record. Many other states don't ask for that. That's a concern of ours, and I'll tell you why in a moment. The change that is being requested in House Bill 6039 is trying to eliminate that. I think that's a problem. Just because right now, the new proposed bill is asking just for convictions, and I think it's specifically, have you ever been convicted of a crime of violence? First of all, a crime of violence has a very specific definition in our law, and you can't say that just because someone was convicted of another crime, they are certainly a good risk for having one of these CCW permits. And again, you could have someone who's arrested but never convicted for a number of reasons. I've had witnesses deceased before trial, and there's nothing I can do to prosecute the person who has been charged with a serious offense. So a dismissal doesn't necessarily mean an acquittal. And if you have a dismissal, you don't have a conviction of that particular crime of violence. In addition, I've been in this office for 17 years. I can't tell you how many cases I've had, especially in the domestic violence arena, where the victims just won't testify, or they'll literally get up on the stand and lie. So again, we don't have the conviction, and so we'll never have the information because the proposal that is here for the new bill, 6039, is taking away that information from us. And with respect to the reciprocity bill, the states who aren't asking that information, we're having them vet people that we're letting walk around our streets with these weapons. Another thing, currently our application asks for individuals, if they have a history or if they've ever been under treatment, guardianship, or confinement for mental illness. To me, that's not even conclusive enough, okay, to tell us whether somebody really is a good risk. This bill wants to get rid of that language and ask instead, whether somebody has been under guardianship or confinement by virtue of being mentally incompetent. That's a completely different animal. And I can give you an example of a case. We issued a permit to a gentleman who asked for the permit because he was a collector of curios and relics. And he represented, even with our question, have you ever been treated or confined for mental illness? He said no. We asked if he had ever been arrested. He gave us one incident where he had been. But even though that was the case, we still granted him the permit. He came back 4 years later, gave the same information, we renewed it again. In the middle of his second term of having that 4-year permit, we get a call from a local police department who tells us that they responded to a call for domestic violence. This person was alleged to have assaulted his adult sister. While the police department was there, found that this person had manufactured from an internet company a replica Attorney General badge that he had attached to a neck chain next to a loaded pistol on his desk. That was obviously concerning to us. He also had an arsenal of weapons in the home that were completely unsecured. Now, he didn't have any children in the home, so there was nothing we could do with respect to that, because that's another statute that I think maybe we could tweak a bit. When we spoke with the police department, they had countless contacts with that individual through the years that we didn't know about. He had been accused of assaulting this sister 4 or 5 other times, but she never agreed to go forward prosecuting him. He also had been hospitalized at both Butler and Bradley throughout the years for suicide attempts and mental illness. Now, this is someone that, despite our best efforts in trying to, fully check and make our state safe, we couldn't even do it. And this bill, 6039, is asking us to take less information. The reciprocity bill is asking us to trust these other states that don't ask it this information. So, again, that point, I think, goes to both bills. 6039 also asks us to just basically automatically renew a license if there's no change in the criminal history. And I think that the language is no material change and no new criminal history. Again, we don't look just at criminal history. You have contacts with your local police department that aren't tantamount to criminal, but they are seriously concerning. You're asking us to not ask for that information in the first instance, and you're prohibiting us from asking for it or even considering it in a renewal situation. That our office has serious concerns about. With respect to the time frames for the application process, you want to put these turnaround times on us. I heard Mrs. Koch talk about problems with the cities and towns. I've not heard about problems with the Attorney General's office, but this statute or this bill would affect us. It doesn't help anybody to have us rush to making these decisions. We're not just sitting here with these applications just deciding not to look at them. We're doing our due diligence. And I heard him say 90 days. I think that's the complete outside, length of time. We're not holding them just to hold them. And with respect to, you have these people who can't continue to work because the renewal application is sitting there. Well, we want people to work. That's why we're issuing these permits in the first place and why we eventually issue them reissue them for the renewals. But with all due respect, for 4 years when your expiration date is. How about put in the application in plenty of time so that we can process it? That's a responsible gun owner. That's a responsible employee who wants to keep his job. with respect to discretion, Mosby versus Devine, it's a Rhode Island Supreme Court case from 2004. It upheld as constitutional our office's right to exercise discretion in granting or denying these permits. Currently, the statute says that basically we require a proper showing of need. This bill, 6039, proposes to take out the word proper. So just any showing of need. That completely eliminates any discretion on my office's part to be able to consider any of these applications. If anyone shows any need, which is a subjective standard, we can't do anything about it. It includes an additional qualifier and a definition as to a suitable person, that we've got to grant these permits to a suitable person, but it then defines a suitable person and makes us look literally at a moment in time, which is the time that we look at the application. And we have to be able to say that the person's not a clear and present danger before we issue this permit. Again, I'd submit that's an absurd standard, because you can't look at the moment in time of the application. We look at the whole person. We look at whatever information we can gather. And the person doesn't necessarily have to be clear and present danger in one moment, but they could be a risk just generally, looking at everything in their history. And again, we don't just look at criminal history. We look at prior substance abuse, mental health issues, these contacts with police departments, and just other known incidents in the community. When we have an applicant file with us, we immediately send a letter to the city or town where they reside, and we ask information from the police chief. And they tell us about contacts that they have. They basically give us information that we can't see just by looking at a criminal database. You're taking that away from us if you're saying we've got to give it to someone who isn't a clear and present danger at the minute we review the application. The bill wants to exempt holders of CCW permits from the 7-day waiting period for purchases of pistols and revolvers. I would be very surprised to hear of any study that says that when we put this waiting period in, your predecessors put this waiting period in, it was probably had domestic violence in mind, disgruntled employees. Please show me a study that says that people who have CCW permits don't have these feelings, don't have these emotions, and don't have these urges. So again, that is not safe for our state. The carrying anywhere provision. Okay, so this bill proposes that we can carry these bills everywhere. I've heard about, the arguments on the side of, pros and cons for schools, but this bill says we can carry in this building. We can carry at the airport. That's anywhere in the state. We can't be doing that. The review process. We have a review process. It's worked for years. There's no problem with it. If somebody's denied, we welcome them into our office. Come on in, bring your lawyer. We'll have a conversation. We'll give you the opportunity to explain to us why we got it wrong. We're fine with that. And we have changed decisions based upon that. If we continue to deny you, you are given a letter. It does tell you why you've been denied. And you have a right of review to our Supreme Court. There are many cases that go straight from a board of some sort and only go by writ of cert to the Supreme Court. And again, we have a 2004 Rhode Island Supreme Court case that says that's the way we do it. That's the proper procedure for doing it in our state, and it's worked for years. Again, I haven't heard of any serious concern or constant concern in that area. I can tell you I have a case in the Supreme Court right now where someone he had his permit revoked, and it was brought before the Superior Court. I asked it to be dismissed for lack of jurisdiction. The Superior Court justice agreed with me, dismissed the case in the Superior Court, and now they have to do it the correct way, which is to the Supreme Court. They're getting their review. Another one with respect to attorney's fees, costs, and filing fees. If somebody basically sues us and they prevail, they're entitled to attorney's fees, costs, and filing fees, which again, you can't be charging us fees and costs when we're exercising the authority that the legislature has given us in a decision-making process. So that's basically, I think, everything with respect to 6039. If I just have just 1 second to see if there's anything else with respect to reciprocity. Oh, the last thing I would just say with respect to reciprocity, I heard, I think it was Whip Edwards say, you know, you drive through, you try to get here, and you have to go through Connecticut or, you know, go through Massachusetts just to get here. Well, we have protections for that in place. In our statute, it allows out-of-state permit holders to travel or pass through our state as long as they don't remain here. If they want to remain here, they have to go through our permitting process. But it's not like we're sitting there with troopers or police officers on 95 and we want to catch people who are driving through the state of Rhode Island with their out-of-state permits. We're not doing that. And I think that is all. If anybody has any...
Kelly, I just had one question because I got a little confused. With the time limits, you were talking about the 90 days, and is it the Attorney General's position that you're okay with the 90 days, 120 days? Okay.
We're not okay with any time frame. I obviously was not involved in any conversation that Mr. Scotia would have had with BCI. I know that we aim to do things, and I'm not positive. I'm not sure if it's 60 or 90 days, but sometimes it can't happen. I mean, we have a lot of other responsibilities. It's not like we don't take this seriously. We're doing our due diligence. Sometimes we're waiting for information back from, you know, that city or town where the person resides, but it's not necessary to say, rush, get this done. And if you don't get it done in a certain amount of time, I think the bill provides for, it's almost like a, well, you lose. Now, either you have to do it or you've got to, you know, do these certain things. This is not a decision that should be rushed.
Okay, yeah, I thought that was your testimony, but then you said 90 days you saw as the outside limit, and that's where I got confused.
I believe that we have already set that limit on ourselves.
I see.
Of 90 days, but can I stand?
That's an internal policy goal.
I can't say that for
okay.
sure.
Right.
Very informally, I recall that being a number.
Got it. Any further questions for Kelly from the Attorney General's office? Representative Price.
Chairman, you said they're not enforcing the law when people come over the state line. If there's a person in an adjoining state that has a carry permit and crosses state line into Rhode Island, they're not enforcing that.
If they are passing through. So I thought the testimony referenced, you know, how close we have our state so small. If somebody's passing through and say they get pulled over, you know, on 95 for speeding, and one of our officers finds that they are carrying, but they have an out-of-state permit, we're not going to arrest and charge that person if they're, you know, we'll ask the questions. Where are you going? Where are you coming from? If they're going, you know, from Virginia to Maine, we're not going to bother them. But if they're hanging out in, you know, Newport for 4 nights to you know, take in the sun, well, yeah, we don't want that.
So so there's cases that they have been prosecuted?
I don't know of...
That you know of?
Not an example, like I said, someone who's passing through that remains for several days, nothing like that. But yes, somebody who doesn't have an in-state permit, I'm sure we've prosecuted somebody for that.
Okay. I guess one other question I had was about the permitting process and, you know, trying to form a standardized, you know, what hoops you have to jump through and what's the criteria. And I just see that, you know, the ever-growing reason for not getting a permit seems to be increasing, like with the mental illness part of it. Granted, someone that's really mentally ill probably shouldn't get one, but the list of mental illnesses and reasons for being counseling is pretty endless and ever-growing. And if you were counseled for, you know, if you were in first, you know, someone passed away, someone broke up with you, a bad relationship, so if you went to mental illness counseling for those things, you know...
And that's a very fair point. And so what would happen, if somebody answers yes on that, we bring them in. Talk to us. Tell us what it was. What was the situation? And it doesn't mean if you answer yes on that we rubber stamp a no, you're denied. That's not what it means. It just means that if we are granted the authority and the grave responsibility to make that decision, we should have that. Wouldn't all of the people living in Rhode Island want to know that we are doing everything we can to make sure that one of these, you know, permits doesn't get into the hands of someone who is seriously clinically depressed. This person that I'm talking about, on 2 occasions, one occasion, his mother called the police department and said, please help me locate my son. He just left with a garden hose. He's going to go hang himself. Another time, we had his treating physician call the police department. His mother says he's left. He took, a bottle of pills, and in fact, he did. He tried to overdose. And so this is someone who, am I saying that everybody who is suicidal is necessarily a mass murderer or going to shoot at a number of people? No, I'm not saying that. But perhaps there's someone who is so, hopeless that they don't care. They don't think that through, and maybe they're angry. And why give them, that extra opportunity to just have something with them in the moment and spontaneously end their life and actually, we'd like to protect that person's life as well, but also to keep them from hurting others.
How many permits has the Attorney General issued? Oh, go ahead.
Actually, that was the other thing I wanted to add. Thank you for asking that. So as of December 31st, 2015, there were over 2,800 active pistol permits that were issued by the Attorney General's office. That does not include the cities and towns. In 2015, there were 563 permit applications. Now, I heard Mr. Scotia say, oh, there's a big problem. Massachusetts has so many more CCW permits than we have. Well, Massachusetts also has almost 7 million people. We have 1. And we can't, and we don't go out soliciting applications. We just review the ones that people bring to us. Of the 198 new applications in 2015, 98% were granted. Of the 365 renewal applications, 96% were granted. So I don't see what others are seeing as far as a problem with that permitting process that would warrant all of the drastic changes that these bills present.
I just hear people say that I'm not even going to apply because it's maybe issue, and there's no real set rules to whether you get it or not. So you can't meet the criteria if you because you don't know it.
But how can we be faulted for that, and how can you say that our system isn't working if the people aren't even trying? Did any of those people say I applied and were denied?
No, you hear the horror stories about the guy spending $25,000 going to Supreme Court and winning.
I actually have, with all due respect, I've only had 2 go there. One was dismissed for a procedural issue, and another one is currently pending. I have not heard of another one because I don't think we have that many, to be honest with you.
Was
there was I don't know.
Oh, was that a city? Maybe that was a city in town.
I don't know if you're speaking of the Godowski case. That was a Providence matter.
Okay, you're right.
We are not the same as municipalities. We have a different enabling statute. We do things differently. Ours shouldn't be touched.
Did you say that it's in the high 90s that get approved? High 90%?
It was 98% of the new ones in 2015, 96% of the renewals.
No, I didn't realize it was that high. Representative Knight, did you have a question? All right, any further questions for Kelly? Thank you so much for being here tonight.